Hey there, it's Nikki Ramirez here. I'm the founder and principal consultant at hranswers.org, popping in for a quick take for leaders today. Wanted to share with you what you need to know about the Pregnant Workers Fairness Act, which is a brand new federal law that employers in the United States need to start to think about and consider as of June 2023. So a little bit of quick information here. This law was effective June 27th, 2023. The Equal Employment Opportunity Commission, or the EEOC, has already started accepting claims of discrimination based on this law as of the recording of this video. And you might be wondering, am I covered by this rule? Does this even apply to me? Well, covered employers are defined as any employer, public or private, in the United States with 15 or more employees. And when you think about who counts as an employee, these are folks that are receiving a paycheck on your regular pay schedule, and they receive a W-2 at the end of the year. They fill out a W-4 when they're hired. So those are our regular employees versus independent contractors who maybe fill out a W-9 and receive a 1099 at the end of the year. So 15 employees, we count full-time and part-time employees, we count seasonal employees, everybody counts. So let's take a look at that in another video, perhaps. If you have questions about your head count, how to determine if this applies to you, please do feel free to reach out. And on that note, at the end of this video, you are going to be invited to reach out to us with your most pressing HR question, whether that's related to the PWFA or some other rule that has you up at night. So what is the Pregnant Workers Fairness Act? Well, like I said, it's a new law that requires covered employers to provide reasonable accommodations to workers or employees who have known limitations related to pregnancy, childbirth, or certain related medical conditions, unless the accommodation that the employee is seeking would cause an undue hardship to the employer. And for the purpose of this rule in particular, the PWFA applies only to an employer's responsibility to make accommodations in the workplace. And so we're really going to dive in quickly here to what accommodations are and what we might be thinking about doing as a process for making accommodations, and also deciding if an accommodation is reasonable or not. So before we get into a couple of the implementation details, let's consider how this fits into existing rules and regulations that apply to employers in the US. So the PWFA, it doesn't replace any other federal, state, or local laws that are already in effect that are more protective of workers who are pregnant or who are affected by childbirth or related medical conditions. This is our federal minimum standard. And it is notable that 30 states and cities have laws that provide accommodations for pregnant workers. And so it's always important, especially when there's conversation around a new federal law or a revision to a federal law, it is important to look at your local rules and regulations and ordinances and your state laws as well. So when an employee comes to you and lets you know that they have a particular need in the workplace that is related to their pregnancy, that need might be considered an accommodation. Employees don't need to know that they're asking necessarily for an accommodation to be eligible for this accommodation. So what I'm saying is, an employee doesn't have to come to you and say in certain terms, I am pregnant and I am looking for an accommodation. I need a stool to sit on while I do my work, or I need to be able to sit down and have regular breaks during my work. The employee simply needs to come to their supervisor or a leader within the company probably and say, hey, I am getting pretty tired standing on my feet for 8 hours straight since I'm pregnant. Do you think it would be possible to get a stool to sit on and do some of my work during the day? So the employee doesn't have to identify the request as an accommodation. It's the employer's responsibility to know that this rule exists and to be good listeners, be caring and compassionate. That's my own add-on. The law certainly doesn't say that, but be caring and compassionate. Pay attention to what your employees are experiencing and what they're asking for. And then, should I be thinking about making an accommodation? Is this person pregnant? Is what they're asking for a modification in their work environment so that they can be successful on the job? If that's what they're asking for, then they are probably asking for an accommodation. So examples of reasonable accommodations that the EEOC has provided us with are things like a place to sit, or the opportunity to drink water. Maybe the person receives closer parking. An employee might be granted more flexible working hours so that they can be most productive on the job, be most successful, and be responsive to the way that their body is behaving as a pregnant person. Employees might be eligible for appropriately sized uniforms and safety apparel. That seems pretty basic, right? But it's not something that's always on the top of the mind of employers. And so as employers who, for example, require employees to use uniforms on the job, we are going to need to think about ordering appropriately sized uniforms and uniforms that fit our pregnant employees as a reasonable accommodation. And when we think about whether or not we're going to be required to provide, for example, an appropriately sized uniform, although it may cost the company some money, we are going to have to weigh out whether or not the cost of making the accommodation is causing an undue hardship for the company. We'll talk about that in the next slide. So let's keep on this list. But again, some reasonable accommodations might be receiving additional break time to use the bathroom, to eat or rest. Employees might be accommodated by being allowed to leave or have time off to recover from childbirth. And employees who are pregnant might be excused from strenuous activities or activities that involve exposure to compounds that are not safe for pregnancy. This is just a very short list of examples that, again, at the federal level, are deemed reasonable accommodations for employees in most cases. And again, we're talking about covered employers who have 15 or more employees. So the question does come up, are employers always required to accommodate a pregnant employee's request? Well, not necessarily, but employers are required to provide reasonable accommodations always, unless the accommodation would cause an undue hardship on the employer's operations. And an undue hardship is defined as something that would create a significant difficulty in operations or an expense for the employer. And the EEOC does believe that employers have a pretty high threshold for investing in resources for employees. For example, let's go back to that idea of providing an appropriately sized uniform for an employee or safety equipment. It would not be unreasonable for an employer to have to spend $100 or so on a custom uniform. Perhaps that would fit a pregnant employee. And so as we do navigate these accommodations, let's be as gracious as possible. And as we are working to be progressive as employers and really ebb and flow with these rules and regulations, let's make sure that we are setting aside dollars each year that we will use to supply equipment, different resources for employees who are looking for accommodations, whether it's under this new Pregnant Workers Fairness Act or some other rule like the Americans with Disabilities Act. So let's think about budgeting for accommodations. Let's think about being as gracious as possible. And we really need a good reason to say no when an employee is asking for an accommodation in most cases. And working with a qualified HR consultant or a labor and employment attorney when the accommodations get a little bit more difficult than you'd anticipate is a really good idea. Just a couple of other things to know here. So what else do we need to know? Covered employers need to stay away from a few different activities here. So covered employers cannot require an employee to accept an accommodation without a discussion about the accommodation between the worker and the employer. In the HR world, we call that the interactive process. So we have to engage in the interactive process, which is a conversation, a dialogue about what might work for the employee and what works for the company. Employers cannot deny a job or other employment opportunities like a promotion or training, things like that, to a qualified employee based on the person's need for a reasonable accommodation. So we have to be careful not to just deny someone a promotion because we know that they are needing to have additional breaks throughout the day or taking time to rest and recover and have a snack and be away from the work team. So let's be careful there. Employers cannot require an employee to take leave if there is another reasonable accommodation that can be provided that would let the employee keep working. So really the bottom line here is that we are looking for ways to keep employees on the job, keep them productive, like light duty assignments, modified schedules, things like that, additional tools and resources, physical resources that might help them do their job still, and without causing them any sort of trouble or physical or mental strain. An example of an accommodation that I've seen in the workplace for a pregnant employee who had lifting restrictions, for example, was to provide them with a dolly that was available to them at all times so that they could move small equipment and supplies around easily. And so putting a dolly in that person's office, this person was an office manager. Most office managers don't necessarily have a dolly sitting around. Maybe their facilities team does, or security or maintenance, but this office manager just requested that, thought that that would make their life easier, and it sure did. That same employer then picked up a nice little small wagon too that the employee could use to tote things around the office, and that was great. Additionally, and finally here, employers cannot retaliate against individuals for reporting or opposing unlawful discrimination under the PWFA, and just can't generally interfere with people's rights under this new regulation. So this is just a quick take. I'm sure that you probably have some questions. You're invited to comment here and share your most pressing HR question, or you can find us over at hranswers.org, submit a contact form, and let's keep this conversation going. Again, I'm Nikki Ramirez, the founder and principal consultant at hranswers.org. Looking forward to the opportunity to talk about this and any HR question that you might have. Thanks for stopping by. Thanks for watching the video, and we can't wait to hear from you soon.